Hello, everybody. This is David Simon here, extremely cheerily doing the second take of this webinar for it to be distributed out to everybody after we don't know what happened with Teams, but yeah, it stopped sharing the slides partway through. And much as looking at our lovely faces was, I'm sure, pleasant for everyone. I think we wanted the slides as well. So yeah, here we are. There we go. So we've got the 4 consultations that we're going to be talking about today. People may be wondering when we're going to stop banging on about the Employment Rights Bill, and the answer is not for a very long time. So we're going to talk today about 4 consultations that are that are in progress at the moment. We're going to talk about what's forthcoming as well. And the reality is that the Employment Rights Bill is going to be bringing about changes to employment law and HR practices for at least another 2 or 3 years. So yeah, we shall be remaining relevant, which is always nice.
So the Employment Rights Bill is the current position, as is up there. It's introduced in the House of Commons on the 10th of October. Last year, now had a 3rd reading stage in the House of Lords, which took place earlier this year, September 3rd September 2025, and it remains a state of parliamentary ping pong, as has been the phrase used in the press, as the government and the House of Lords have yet to reach an agreement. On the 28th of October, the House of Lords pressed for several amendments that the Commons previously rejected, and it will now return to the Commons, and royal assent will only follow once there is an agreement on the final wording. Although the ongoing delays are causing uncertainty, it's expected the bill will be given royal assent in autumn 2025. Is that still the same, or has it been pushed back? Do we know?
Well, it does say autumn 2025, and does winter not officially start until December 2025?
Yeah,
so we've got a few weeks yet.
And becoming Employment Rights Act, when it does receive royal assent, but it doesn't mean all changes will come into force.
Okay, so the first consultation that we're going to talk about today is the right of trade unions to access workplaces. So this was launched on the 23rd of October, and it explores the introduction of the new right, which gives trade unions the right of access to workplaces to meet with, support, represent, recruit, or organise workers, and to facilitate collective bargaining. Trade unions will be able to request access from employers, and if employers refuse, the trade union could apply to the CAC, that's the Central Arbitration Committee, to have access arrangements imposed. So a number of points being consulted on. Firstly, the form of the request. Feedback's being sought on what form a union request for access should take, how it should be submitted, and what information will be needed to demonstrate that the request is legitimate and made for a valid purpose. In terms of the employer's response, employers are being asked how they should be required to handle access requests, including what time limit should apply for responding and whether they have the right to refuse or negotiate access. The consultation also explores what would constitute a reasonable refusal and how any disagreement should be resolved. The government's proposal is that employers will have 5 working days to respond to a union's request for access, and following that, they will then have a period of 15 days to negotiate access terms. If terms are not reached by the end of this period, then the union can notify the CAC, and the CAC can begin its process of deciding whether or not access is to be enforced. The government has said they're going to set a maximum they're proposing to set a maximum period of 25 working days that can elapse between when an access request is made and when an application to be made to the CAC. That's to ensure that access requests are dealt with quickly and employers are not then left in an ongoing uncertain position about whether the request for access will be referred to the CAC. That will offer obviously greater certainty, but it may also prompt unions to submit applications to the CAC earlier than they otherwise would, just to safeguard their position. In terms of dealing with disputes, feedback is sought on how the CAC should assess whether access should be granted, and if so, on what terms. So relevant factors may include the type of workforce involved, the likely operational impact, and the overall balance between access rights and employer interests. So that will all be determined against the backdrop of what are called the access principles outlined in the Employment Rights Bill, and they are fourfold. 1, trade unions should be granted access for legitimate purposes in a way that does not unreasonably disrupt the employer's operations. 2, employers are expected to take reasonable steps to facilitate access. 3, physical access should not be denied solely because digital access has been granted or vice versa. 4, full refusal of access should only occur when it's reasonable to do so. The government's also seeking feedback on additional factors the CAC should consider when determining whether and how access should be granted. And those include, so may include, subject to the result of the consultation, excluding businesses with fewer than 21 employees, setting a 2-year expiry date for statutory access agreements, allowing the CAC to refuse access to an independent union is already recognised for the relevant group of workers, incentivising businesses to go through a voluntary recognition process to avoid getting into a dispute. Ensuring employers are not required to commit excessive resources, such as building new meeting rooms or installing new IT systems, introducing a model access agreement with union requests aligned to it, more likely to be deemed reasonable, considering weekly access as generally reasonable, and requiring unions to give at least 2 days' notice before accessing the workplace. In terms of enforcement and sanctions, the consultation introduces a penalty framework for non-compliance with access agreements and invites your views on enforcement mechanisms, sanctions levels, and whether appeal or mediation routes should be provided. Currently being proposed is a 2-tier penalty system. It's a standard cap, so not automatic amount, but a cap of £75,000 for the first offence, and then an increased cap of £150,000 for repeated violations. That consultation is going to close on the 18th of December. In terms of what it means for employers, well, review the consultation to understand what's being proposed for union access and what's going to be required of businesses, so you can get ahead of the curve when the final shape of the trade union access right is announced. Review any existing agreements that you've got with trade unions to make sure that they're going to be compliant, or that you're going to be able to change them so that they are compliant, and prepare for requests in terms of who's going to handle those, how they're going to be handled, bearing in mind, in particular, the tight timeframes for turnaround for dealing with requests.
So consultation 2 is the duty to inform workers of the right to join a trade union. The bill will introduce a new requirement for employers to give a statement to their workers informing them of the right to join a trade union at the start of their employment and at other times. The consultation was launched on the 23rd of October 2025 and seeks views on how this requirement should be applied in practice, including 1, the content of the statement, what information should be included. The government proposed that the statement would include a brief, neutral overview of the functions of a trade union, summary of the statutory rights in relation to union membership, list of all trade unions that the employer recognises, if any, and a signpost to a gov.uk website with a list of trade unions. Number 2, the form of the statement. Should the statement be included in the particulars of employment? Does it need to be in writing, or can it be digital? Should employers use a government-provided template or create their own version? It will be important for the government to ensure the standard written statement remains a neutral factual document, particularly given that the individual right to choose not to join a trade union is protected under the European Convention on Human Rights. Delivery method. Should the statement be given directly, i.e. by email or letter, or indirectly, such as on a staff notice board or intranet? Should the method of delivery differ between existing employees and new employees? Frequency of delivery, whether employers should be required to remind employees of the right to join a trade union on an annual basis, or is it a one-off? And in practical implementation and burden, how can employers deliver this duty in a way that is effective but proportionate? And what is a reasonable time frame for implementation? And how should smaller employers deal with this? So the consultation closes on 18th December 2025, and details on how to respond are on the gov.uk website. What employers should be doing now is keep an eye on the outcome of the consultations and developments of the ERB, review employment contracts and written particulars, and plan how the statement will be issued, audit induction materials, handbooks, policies for reference to trade unions, and ensure HR and managers understand the upcoming changes.
Okay, so the third consultation is on bereavement leave entitlement. So this is a consultation on unpaid bereavement leave, and that's going to be a new statutory right from day 1 of employment. That's separate to parental bereavement leave. So parental bereavement leave provides employees with up to 2 weeks leave following the death of a child or stillbirth after 24 weeks. Unpaid bereavement leave will cover the death of a loved one So that will be broader than just a child, but it's yet to be defined exactly what a loved one will be for the purposes of the right, and loss of pregnancy as well prior to 24 weeks. The consultation seeks views on eligibility, duration, flexibility, notice, and evidence requirements. In terms of eligibility, the consultation recognises family structures in modern Britain are diverse and evolving. The consultation asks which relationships should qualify as immediate family. Should it be immediate family? Should it be extended family? Should it be close friends? Pregnancy loss, it asks whether leave should be limited to whoever was pregnant or include others, such as partners, intended parents, and those in surrogacy arrangements. In terms of leave duration and timing, the Employer Rights Bill sets out the bereavement leave will be for a minimum of a week, could be longer, and there will be at least 56 days to take it from the date of the loss. So again, that may be extended. Feedback sought on whether it should be extended, whether the amount of bereavement leave should be longer, and whether it should be the same amount of leave in all types of scenarios, so the difference between a close friend perhaps and immediate family, and also whether leave should be taken in one block or flexibly in smaller units. In terms of notice and evidence, the consultation asks how much notice should be required and whether any evidence should be provided. It acknowledges that in cases of pregnancy loss, requiring proof may be distressing or impractical. I suggest that requiring proof in the vast majority of situations is likely to be distressing and probably impractical as well. Business impact. So the government recognises that many employers already offer compassionate leave, but seeks views on how consistent minimum standards and guidance might help. So in terms of what employers should be doing, well, of course, keeping abreast of developments as they happen, so that you're ready to go whenever the new rights are introduced. Review and update policies and train line managers and HR so that they know what types of leave people are entitled to. And that actually has a closing response of the 15th of January 2026.
So the final consultation is number 4, and the government proposes legislation making it unlawful to dismiss pregnant women, women on mat leave, and those returning to work for at least 6 months post-return, except in specified circumstances. The key issues are circumstances for lawful dismissal. Well, the consultation asks which grounds, conduct, capability, redundancy, statutory provision, or some other some other substantial reason could continue to apply to pregnant women and new mothers, and whether a new stricter test should apply. The government proposes 2 options. Option 1, introduce a general new test for fairness. Under this option, employers would still be able to rely on any existing fair reasons for dismissal, but they'd also be required to meet a new stricter standard when relying on that reason to dismiss a pregnant woman or a new mother. An example is that employers would be still required to show a fair reason and also show that letting someone go is, for instance, necessary to avoid serious harm to the business or other staff. And then option 2 is narrowing the scope and or remove some of the fair dismissal reasons. And that approach involves limiting the 5 potential fair reasons for dismissal under the ERA 96 when applied to pregnant women and new mothers, potentially removing some altogether. Stakeholders have suggested narrowing the conduct ground to apply only in cases of gross misconduct, meaning dismissal would only be permitted for serious breaches such as theft or violence, but not for more minor issues like lateness or poor attitude. Other suggestions include removing capability as a fair reason, so dismissal for poor performance would no longer be permitted, and removing some other substantial reason which prevent dismissals based on any other grounds like breakdowns in working relationships or conflicts of interest. And the consultation also looks at narrowing reliance on redundancy as a potentially fair reason for dismissal, even further to only be permitted in exceptional circumstances. In terms of timing, the consultation seeks views on when enhanced protection should begin, for example, from the point the employee notifies the employer or from the start of pregnancy, and how long it should continue after returning to work, such as 6 months post-return or 18 months from birth. The government is considering whether these protections should also apply to other parents, such as those taking adoption leave or shared parental leave, and how best to raise awareness of these rights. The consultation asks for input on how to assist employers in implementing these changes and how to reduce unintended consequences, such as employers becoming hesitant to recruit individuals of childbearing age. So what should employers be doing? Review policies and procedures related to pregnancy, parental leave, and dismissal to prepare for enhanced protections. Train managers on the new protections. ensure hiring practices remain compliant and are not unduly impacted by the new protections, consider how to manage administrative burdens, such as tracking protected period. Sponsors are made by the 15th of January 2026, and details on how to respond are on the gov.uk website.
Okay, so those are the four ongoing consultations, but as it probably hasn't escaped your attention, that there are still a lot of matters and proposals that were raised in the Employment Rights Bill that aren't covered in those four we've just mentioned. So over the course of, this is the rest of 2025, but frankly, they're going to have to get a move on. Certainly early 2026, we can expect to see consultations on employee protection for unfair dismissal from day one, including procedures during the statutory probation period. Those will obviously be absolutely key. We're all familiar with the significant change between coming up to 2 years and 2 years, and the rights that an employee accrues once they've got 2 years or just shy of two years employment, once you've added in the statutory notice period. So these new statutory probation periods and the detail around those are going to be something that's really interesting to see and absolutely key to understand, to ensure that organisations are protected moving forward. Other consultations, ending the exploitative use of 0 hours contracts. So we've seen lots of detail around that and what might be proposed, but yet to see the formal consultation. Fire and rehire practices, trade union measures, including protection against detriments for taking industrial action, preventing blacklisting. Of course, it's not unexpected that a Labour government is going to be introducing far greater protections around unions and making sure or trying to put into place measures to make sure that unions are more involved in workplaces. Tightening tipping laws, collective redundancy procedures, and flexible working hours.
And then finally, what is next? Well, as we said at the beginning, there's the parliamentary ping pong that's going on. And although the delays are causing uncertainty, the bill is expected to be given royal assent in autumn. We said this at the beginning. And whilst the bill establishes the broad legislative framework, many of those key reforms will be set out in more detail later through secondary regulations and statutory codes of practice. And to help employers prepare, the government have published a phased implementation roadmap, providing early notice of when specific changes are expected. However, it remains unclear whether this timeline will shift if the bill experiences delay as it progresses through Parliament.
So what should employers be doing now? So, of course, many of the reforms are some way off and going to need to be analysed. You can stay ahead of the curve. So train managers and HR teams. Line managers are going to need upskilling in areas such as fair dismissal procedures and new leave entitlements. Ideally, if people are already upskilled to a certain degree, it's going to be a little bit easier once the new rights come in. Keep an eye, of course, on updates to consultations and the outcomes of those for when the detail is confirmed. Everything we've said today is just what's proposed at the moment or options for what might be proposed. And then review existing policies and contracts to make sure that you're compliant and ahead of the curve.
So there's the employer retainer download thing that you can do, to download the retainer info.
Yeah. None of this webinar today was advice. That was probably obvious from the content, but it's worth saying anyway. But an extremely good source of advice on these matters, particularly after they're implemented and you're having to actually enforce them, is Robinson Ralph.
Thank you. And then there's there's us. So there we go. Thank you so much.
Cheers, guys.